Hello and welcome to Verdictum. I'm Sheetal June and you're watching today's legal news where we update you with the latest legal developments across the country and world. Starting with the headlines. Balance of convenience lies in his favour. Delhi High Court protects personality rights of Telugu actor and producer Vishnu Manchu. Recording conversation with officer inside police station not an offence under Official Secrets Act, Bombay High Court. Bar Council of India has no power to pass gag orders restraining speech of advocates, Karnataka High Court. US court finds Cognizant guilty of discrimination against non-Indians. Now the news in detail. The Delhi High Court has provided protection to the personality rights of Telugu actor and producer Manchu Vishnu Vardhan Babu and granted interim injunction to him. The court was dealing with a suit filed by him for permanent injunction restraining defamation, infringement of copyright, misappropriation of personality and publicity rights, unfair competition, passing of damages and redemption of accounts, etc. A single-judge bench of Justice Mini Pushkarna said the plaintiff has demonstrated a prima facie case of grant of permanent injunction, and in case no ex parte ad interim injunction is granted, the plaintiff will suffer an irreplaceable loss. Further, the balance of convenience also lies in his favour and against the defendants. In this case, the plaintiff Vishnu Manchu filed the suit to protect his name, voice, image, likeness and other elements of his persona which are distinctive and unauthorized use of which by the third party is likely to create confusion and deception amongst the public. The suit also pertains to the violation of the plaintiff's moral rights in his performances conferred upon him by the virtue of Section 38B of the Copyrights Act 1957. As an actor, the plaintiff had acted in many cinematographic films and thus enjoys moral rights in his performances in such films. In the context of the claims in the proceedings, the defendants were extracting clips from movies or other cinematographic works which pertain to performances of the plaintiff and his other interviews for the purpose of creation and communication of videos which bring ridicule to the plaintiff. The Aurangabad bench of the Bombay High Court has ruled that the recording video or audio inside a police station does not fall under Section 3 of the Official Secrets Act which pertains to spying. With this observation, a division bench of Justice Vibha Kankarwadi and Justice S.G. Chapalgaonkar struck down charges under the Act filed against Mumbai Police Constable Santosh Athare. The police in the case had invoked the Official Secrets Act against two brothers, but the court noted that Sections 2(8) of the Act defines prohibited places and police stations are not included in that definition. The court also clarified that Section 3, which deals with penalties for spying, does not apply to actions taken within a police station. However, the court declined to quash other charges in the FIR, including those Sections 120B Criminal Conspiracy and 546 Criminal Intimidation of the Indian Penal Code. The case arose after Subhash Athare stated in the complaint that 3 persons had illegally trespassed in the house on April 21, 2022 when no one except their mother was present. The Karnataka High Court has emphasized that the Bar Council of India has no power to pass gag orders restraining the speech of advocates or even the members of the Bar Council. The court was dealing with a writ petition preferred by senior advocate S. Basava Raj, challenging the proceedings initiated by the BCI in terms of its communication in April 2024, by which certain restrictions were imposed upon his practice. A single-judge bench of Justice M. Nagaprasanna held, general supervision and control in the considered view of the court would not clothe with any power to the Bar Council of India to pass such gag orders restraining the speech of advocates or even the members of the Bar Council, as it is general supervision and control and not control over the speaking of advocates. The bench remarked that the chairman of the BCI ostensibly cannot pass any such gag order which takes away the fundamental right of any advocate, and that the power of the courts, either competent civil court or the constitutional court, cannot be permitted to be usurped by the chairman of the BCI as is done in the case at the hand. A US district court has found Cognizant Technology Solutions guilty of discrimination against non-Indians, adding the company's conduct meets the standard for punitive damages. The jury verdict in the decade-old class action suit is based on a complaint by Washington, D.C.-based litigation boutique on behalf of the employees who said they were discriminated against non-Indian workers. Some of the employees said that they were terminated after the company put them on the bench. On the bench is an industry term to describe a situation where an employee is temporarily without a project but on the company's payroll waiting for next assignment. The plaintiffs had proven that Cognizant is engaged in a pattern or practice of intentional discrimination against non-South Asian employees based on race and non-Indian employees based on national origin, both of whom were terminated from the bench, the court said. Cognizant has called the ruling disappointing and decided to appeal against the same. That was all on today's legal news. Thank you and keep watching Verdictum. Subscribe to our channel and download the Verdictum app on iOS and Android devices for the latest legal updates.